Our guest today is a distinguished attorney and an outstanding public official. Our guest today is the president of the American Bar Association. He served 2 four-year terms as mayor of the city of Detroit and served roughly 10 years as a justice of the Michigan Supreme Court. In his final year on the bench, Michigan Lawyers Weekly named our guest today as the most respected judge in Michigan. Ladies and gentlemen, please welcome to the City Club of Chicago, the president of the ABA, Mayor Dennis Archer. Your Honor. It's all yours. It's all yours.
Thank you. Thank you very much. Given this wonderful crowd of outstanding people, I could perhaps talk about a lot of different issues, because what is going on by so many people in this room and the causes and the issues that you support, the American Bar Association, I think, has a point of view or policy upon those kind of issues that are important to you. But before I begin the text of my remarks, please allow me to ask all of the members with whom I have the privilege of working for and with, who are on the staff of the American Bar Association, past and present, would you please stand? Those distinguished staff members are the men and women and more like them. We have just over 900 employees who work in Chicago and in Washington, D.C. that allows our sections and divisions and the work of the American Bar Association that touch and concern the American people and our profession. And they do just an outstanding job, and you all honor me with your presence today. For your own information, in terms of volunteers who continue to guide the association and to work with us, one of the most powerful committees that the American Bar Association has is our Federal Judiciary Committee. That is the committee that is, in effect, has an absolute Chinese wall around them. They contribute to no party, no anybody, no anything. They do not involve themselves in the affairs of the American Bar Association to keep them pure. Why? Because when we learn of a nomination from the President of the United States for a person to serve on the federal judiciary, that name goes to that committee. And that committee has a responsibility for evaluating and rating a candidate or a nominee. They do not evaluate on the basis of philosophy, but rather they look at the integrity, the competence, and the like. As a general rule, in the past, we've had a new chair each year. But upon the recommendation of Bob Evans, who runs our Chicago or Washington office, he felt it would be important to have someone for 2 years for more continuity. So Robert Gray, who is the president-elect of the American Bar Association, who comes from Richmond, Virginia, he and I agreed upon an outstanding lawyer here in Chicago, Tom Hayward, who's right there. Tom, would you stand up? So, Judge Williams, when the call comes in and asks you to go to the United States Supreme Court in the next 2 years, you know that you'll be interviewed by Tom Hayward's committee. We have a board of governors, and on our board of governors we have people who are responsible for 3 different committees. The most important, in my view, committee, only because I am a past chair of it and I know how hard they work, is a person who, if you are ever having a divorce, and I'm not talking about matrimonial, but if anybody ever needs someone who is going to leave their high position as a president or vice president or something as a company, you would want to go see the chair of our finance committee of the Board of Governors, Laurel Bellows. Laurel, would you stand up? I hope that, Dean Chappelle, you'll forgive me and all the others that I could go around the room, but I am going to pick on one guy and call him out. Because the American Bar Association wanted to set some medical standards for the number of cases that were clogging our courts here in Cook County and in New York, and our federal courts in Wayne County, my own county at home in Detroit. And so we took an issue to the House of Delegates of the American Bar Association to set some medical standards on the issue of when a person should be able to file a lawsuit having medical injuries from asbestos. And one guy stepped up who is a plaintiff's lawyer, an outstanding plaintiff's lawyer, but agreed with us, much to the chagrin of our friends and the American Trial Lawyers Association, with whom we generally do a lot of work, and he's a member of. Terry Levin. Terry, stand up. Thank you. National security, civil liberties, in a post-September 11th world. I became president of the world's largest professional organization, the American Bar Association, at our annual meeting last month. We have over 405,000 members, and we represent all aspects of our profession. One of our responsibilities, and that we take this very seriously, is to uphold the rule of law and to assure the fair administration of justice. And our model is defending liberty and pursuing justice. I became president at a very challenging time, both for our legal profession and for our country. It is a time of great uncertainty. Our nation lives under the shadow of a terrorist attack, not knowing if or when another will occur. We have troops stationed abroad, both to guard against terrorist threats and to secure the peace in Afghanistan and Iraq. We are constantly reminded of the tremendous sacrifice that our troops make every day and every moment to secure peace and stability so that our country can prevent and defend against terrorist attack. We owe a great debt of gratitude to the men and women who serve this country, to their selfless commitment, their fortitude, and their unwavering service to our country. We take for granted, quite frankly, the ability to come here to this great banquet hall, have excellent food, engage in friendship, talk about issues of relevance and that which is important to all of us. And then we go back to our respective responsibilities, driving or taking a cab or however we get to and from. And then in the evening, we go home, we enjoy ourselves, we go out on the weekend. We do all of that as a result of the men and women who are over there in Iraq and in Afghanistan, making our lives much better and preserving freedom. So I don't think we can underestimate the value of their service, nor can we do anything less than extend our greatest support financially, morally, and spiritually for their continuing efforts both home and abroad. I mentioned that these are uncertain times. Our collective sense of security and safety has been shaken. Who would have thought? You think about the world wars that we have fought. You think about all of the challenges we faced in Korea, Vietnam, all of them. they have generally been on somebody else's soil. Yes, we've been the victims of our own attacks by Americans who have taken out the building in Oklahoma and other places. But for us to have it on our own soil, it is interesting how we have all responded. We have responded with courage, with conviction, and commitment. In the legal community, our commitment to protecting America's values and the commitment of lawyers and judges and lawmakers and others, both in President Bush's administration and in the legal profession in general, has never been stronger nor more important. We especially appreciate that since the tragic incidents of September 11th, 2001. We've been confronted with issues and concepts that we've never imagined we'd face, issues that affect what we think, how we act, and believe about ourselves and others. Those terrible attacks changed a great deal about this country. And above all else, they forced us as Americans to face who we are as a nation and what we stand for, to prioritize our values and to make changes necessary to protect those values while protecting ourselves, our nation, and our way of life. In the last 2 years, we've been working through a very important balancing act. The struggle to preserve civil liberties and democratic values while protecting ourselves from terrorists living in foreign lands or on our own soil. We continue to work on that balance as we face new national security challenges nearly every day. It has been our hope since September 11th that the American Bar Association has provided great service, both to the country and to its leadership, by assisting with questions involving the rule of law. With each new challenge to our legal system, to our system of justice, we've always had lawyers working with lawmakers both in and outside of the Bush administration to determine how best to confront the latest legal hurdles. Policies have been brought before our policy-making House body called the House of Delegates, so that our association can go on record with its views on how to handle specific legal issues and how they should be addressed and shared with the American public. You should know that it's estimated, working with the Census Department and the Bureau of Department of Labor, that there are 1,050,000 licensed lawyers. About 750,000 of us practice law. Our House of Delegates represents the profile. We've got about 535 lawyers who serve in our House of Delegates. The overwhelming number of practicing lawyers are sole practitioners. And the number of lawyers who practice in law firms, the overwhelming number practice in law firms the sizes of 2 to 10. Those lawyers who belong to firms that have 50 or more lawyers are the exception to the rule of those who practice law. In the House of Delegates, you'll find sole practitioners, lawyers who practice in small law firms. You'll find lawyers who practice almost virtually every type of practice area that you can have in mind. They come from big cities, small towns, and rural areas. This is where the debate takes place on policy issues. We have an informed debate, and I'm very proud of our association when we take on issues and pronounce a new policy. Immediately after the September 11th attack, we formed a task force on terrorism to look into the law-related public policy issues that arose from the attacks. The most salient one, and the one that quickly became the focus of the task force, was the possible use of military tribunals to try terrorists. The question of whether and how military tribunals could be used was one that stirred much debate in the legal community. The initial military order establishing the commission was very broad. Many lawyers thought it threatened the fundamental concepts of justice and due process. The task force was concerned that in prosecuting the war on terrorism, we might give up too many of the things that this country stands for: justice and individual rights. Task force members deliberated on how best to ensure fairness and justice in employing military tribunals. And in February 2002, there were 2 resolutions brought to the House of Delegates, both of which passed. First was the policy expressed full support for President George W. Bush and his call to bring to justice all the perpetrators of global terrorism and those who harbor terrorists or give them aid. The vote in the House was unanimous and reflected the association's commitment to supporting the administration and its effort to protect national security. The second resolution spoke to the use of military tribunals. We called on the government not to subject United States citizens, resident aliens, or those living lawfully in our country to the possibility of being tried by military tribunals. If the tribunals were to be used, we said, there should be guidelines that ensure fundamental fairness, including that those detained have access to counsel, be given prompt notice of charges, have access to an interpreter, and not being held indefinitely without trial. The preliminary report of the task force was sent to Capitol Hill and the Department of Defense, and we believe that our recommendations were very helpful to the Department of Defense in developing what became the final guidelines for the use of military tribunals, because what they did was to modify what they originally had proposed. Shortly thereafter, the American Bar Association created a task force on the treatment of enemy combatants. When 2 United States citizens were picked up and held in the United States in connection with terrorist plots. As lawyers and officers of the court, we feel that we have an important role to play in the debate about how to treat these individuals. The task force has taken its mission very seriously and worked diligently to come up with a report that outlines principles to follow in pursuing and trying American citizens who are suspected of being terrorists. The report was adopted as official ABA policy in February. The report reiterates the association's support of the efforts to root out terrorism and to bring terrorists to justice. But its concern is that these efforts be done in the American way, so that United States citizens being held as enemy combatants have access to counsel and to courts. The report asks that Congress establish standards and procedures governing the detention of United States citizens, that citizens detainees should have access to judicial review, and that citizen detainees should not be denied access to counsel, which is crucial to those challenging their detention through an habeas petition. The report clearly does not say that American citizens held as enemy combatants should never be detained. It simply says that there should be guidelines for such detention. It does not say that American terrorists caught in Afghanistan or in any other foreign country must immediately be given a lawyer and access to our courts. But it does say that U.S. citizens detained in or brought to the United States should enjoy the protection of the United States Constitution. That report has been forwarded to Congress and to President Bush's administration. Finally, just last month at our annual meeting in San Francisco, the Enemy Combatants Task Force brought a resolution to the House regarding the rules for civil defense counsel in military tribunals. The issue came up this summer when the Department of Defense issued procedural rules for defense counsel, and it became apparent that trials for several of the detainees being held at Guantanamo Bay could begin any day. The basic concern of the task force is that civilian defense counsel who represent detainees be able to render zealous, competent, and effective assistance of counsel to their clients. The rules as initially drafted impeded such effective assistance. The task force believed, and the House of Delegates agreed, that the American Bar Association needed to go on record to respond to the Department of Defense rules. In August, we passed a resolution that had the following: that the government should not monitor privileged communications, i.e. listening on telephone conversations, or interfere with confidential communications between defense counsel and clients. The government should allow defense counsel to be present at all stages of commission proceedings and should have access to all information necessary to prepare a defense. Next, the government should ensure that defense counsel be able to consult with other attorneys, seek expert advice, counsel outside the defense team, and the government should not limit the ability of defense counsel to speak publicly consistent with the model rules of professional conduct and their duty not to reveal classified or protected information. Our resolution has been sent to the Department of Defense and to the leadership in Congress. What is critical now and must be done on an ongoing basis is a vigorous review of the new policies and procedures that we adopt in fighting the war on terror, both here and abroad. We need to be sure that our policies are consistent with what we need and expect of our government and what our law enforcement officials. We've all heard concerns about the U.S. Patriot Act, passed 45 days after the attack on September 11th. Many groups and individuals have now said that the expanded surveillance, detention, and other powers it gives law enforcement threatens our civil liberties. Their concerns are real, and we must take them seriously. The Bush administration and Congress must work together to ensure that the Patriot Act provisions are working properly. And they must have a dialogue with the American people to engage them on what these expanded powers are, why they are needed, and how they are working. Congressional oversight is imperative. That is already in the law. It requires the Attorney General's office to report to Congress, whether they do it in camera or through the public or public forum. They should report on what has been done, how it's worked, how it saved lives, how it stopped things, and so that at least our congressional members can come home and assure everybody, hey, this thing works, we've heard it, we're satisfied, etc. So, the administration needs to provide Congress any and all information about how the Patriot Act is working. And Congress must ensure that the expanded powers are working properly. In these challenging times, the administration and Congress only benefit from mutual support and cooperation. Their work together through an open dialogue with the American people will ensure the trust and confidence that is so critically needed for Americans to rest assured that their lives and liberties are safe and protected. The world has changed a great deal since September 11th. Our Defense Department is adjusting and changing to meet the new needs of our country and our allies so that we can fight new wars, unlike the wars we've had to fight in the past. Similarly, the justice system must change, must adjust, and must reflect the new security needs. We must mobilize lawyers and lawmakers to adapt the rule of law to suit new, changing circumstances and new threats that we face every day. I've charged an American Bar Association group to look into the laws as they relate to our armed forces, to see what new legal protections might now be needed for our men and women who are called to serve for longer and longer periods of time. We've just heard where many of our reservists who thought they were going to be away for 6 months will be there for now a year or more. So we need to find ways to ease their burden as they are called up to go to foreign lands, leaving their family, their friends, and jobs and lives behind. Lawyers from several ABA groups will work together to identify areas of the law that need to change, and they've already identified issues involving family support, child custody, housing concerns, employment rights, and others. Our goal is to make life easier for those who choose to serve our country in the military, and I look forward to their work. In closing, let me say that as lawyers in the pursuit of liberty and defense of justice, as we in this country must be ever vigilant that our actions and our policies attest to what we are and, more importantly, what we stand for. We must not abandon our United States Constitution or our Bill of Rights or our beliefs. Rather, our democratic principles should guide us as we make decisions about how to proceed in these challenging times. We owe it to ourselves, we owe it to our founding fathers, and most importantly, to the generations that will succeed us, our children, our grandchildren, our great-grandchildren. We must work together to assure that our society remains free and fair and that our democratic values prevail. Here. Now it's my understanding for the next few minutes, as is habit and custom, there's a microphone there in the middle, and if anybody's got any questions, I'd be delighted to have somebody else answer them. But if you have any questions, please step up to the microphone. Fair game, any issue, any topic. I'm ready. Going once. Going twice. Put on those rollerblades if you're getting over there.
Those of us who are teachers know that the first one is always the most difficult to get anybody to stand up and say anything. Those of us who are lawyers, I think, are used to being way down the credibility list. Not always below the used car salesman, but somewhere hovering around it. One of the things that is a matter of enormous concern to many of us, though, is the fact that the judicial branch, the judiciary, has sunk enormously in terms of its acceptance, its credibility with the American people, and that is a very scary thing, perhaps even more scary right now in light of the kinds of things that you've been talking about, the challenges that we have right now. Do you think that is true? Do you have any explanation for it, and do you think there's anything we can do about it?
Well, first of all, let me just indicate that I disagree respectfully with your predicate, and let me tell you why. First of all, as it relates to our profession, I think what has occurred post-September 11th has elevated a higher regard for the legal profession, because it is the legal profession, after all, that Shakespeare wrote about and used in the proper context is most appropriate for where we find ourselves today. Every now and then you'll see on sweatshirts or T-shirts, or somebody will make some snide remark about the first thing you do is kill all the lawyers. But when you take it in context, it says if you want tyranny to succeed, if you want to destroy a democracy, the first thing you do is kill all the lawyers. Why? Because we raise our hands to take an oath to represent the oppressed and the defenseless. And that's exactly what the American Bar Association does. That's what the Chicago Bar, that's what the Illinois Bar, and that's what lawyers do. And we've demonstrated that in terms of being respectful but disagreeing with the President of the United States, disagreeing respectfully with the Attorney General, and reminding both that there's a United States Constitution, as amended in the federal statutes and the like, that we all must respect. So that I believe citizens respect our profession for reminding all of us of our civil liberties and civil rights. And the judiciary, frankly, is under attack by some who want to enter into mind games. For example, I want to know from you, Judge, is the question, how have you been sentencing people? And if you've been sentencing people and you've been moving away from the sentence guidelines, I want to report on that judge. I find it interesting that Mr. Justice Anthony Kennedy comes to the American Bar Association and says, among other things, would you please take a look at whether time has come to restore and give back to the judiciary the discretion on taking away the need for mandatory sentences, whether it happens to be state or federal courts. I mean, these are interesting times, and I think the respect for the judiciary is high. For commentators who've got nothing else better to do, they write about issues, but if you go to the public and say, what is strong about this nation, they will tell you the courts. And if you ask people, what do you think about lawyers, they'll have some obvious comments to make. I mean, if you go to a website, I've never looked at it, but they've got 420,000 lawyer jokes. I don't think any of them are funny. Having said that, let me also suggest to you, if you say to the same person, have you ever had a lawyer before? Have you ever used a lawyer? So, yes, I have. Well, what do you think? Oh, my lawyer's great. My lawyer. You ask them, ours is an adversarial profession. We stand up for our clients. Don't ever frown or walk away from our profession. We do good work. Yes.
Jeff Berkowitz, host and producer of Public Affairs, airing every Monday night at 8:30 on Channel 21 throughout the city of Chicago. I wondered, you just commented a bit on lawyers and the judiciary. As you know, the Democratic minority in the U.S. Senate has filibustered a few, some would say more than a few, judicial appellate appointments or nominations in the Senate. And others have argued that that is unprecedented in terms of using the filibuster with respect to those judicial nominations. Some have disagreed. And I wondered what your view is. Is there precedent for that? And two, what's your view? You might distinguish between your view and the ABA's view if they diverge, as to the appropriateness of using the filibuster with respect to judicial nominations.
Well, let me just say to make the following observation. Let's start with Mr. Estrada. Mr. Estrada worked in the Clinton-Gore administration. He was rated, I think, well qualified by the Federal Judiciary Committee of the American Bar. And as they went through the nominating process and the hearings before the Judiciary Committee, a request was made, as I read, by, I presume, someone in the Democratic minority for some writings. Someone made a decision, whether it was Mr. Estrada or whoever was managing him, that they were not going to supply the writings that were made by Mr. Estrada when he was in the Clinton-Gore administration. I don't serve in the United States Senate. The American Bar Association does not serve there either. We don't tell the United States Senate what they should or should not do. We made our evaluation. I will point out that at least Mr. Estrada and the others have gotten to the point where they are able to at least have gone through the Judiciary Committee. And they are on the floor for discussion to be voted up or down as to whether to be confirmed for the respective seats for which they were nominated. I would respectfully remind you, as I'm sure that you can do through any Nexus search, that there were a number of people nominated by President Clinton who never even saw a hearing, was never provided a hearing to even get to the point where they could even be filibustered. That occurred through a Republican majority. I have no opinion. The American Bar has no opinion. If you've got an angst, your angst is with the United States Senate, not with the American Bar Association. We've done what we're supposed to do. And what I find most interesting is that one of the things that I've always observed about the United States Senate is that even in hard political times where they've been bumping heads on a lot of issues, you'd see Senator Hatch and Senator Kennedy coming together on a number of issues and others doing the same thing. But I have never seen the use of circumventing the mutual respect that they've had for each other, as Senator Hatch and Majority Leader Frist has moved to bring to the floor people where United States senators have put in a blue slip opposing any candidate going forward from their particular state. That's just observation. And if the nominations go through because the vote is there, then of course it will be interesting to see what happens to the collegiality in our United States Senate. They've been doing this for a long time, much longer than I've been president of the ABA. When we elect people to serve office, whether they bear the title Democrat or Republican, I will tell you the people who live in Detroit or Chicago or someplace, wherever it is in America, they want people to work together on issues. And they want them to work together on issues for the good of the country. And sometimes somebody starts something, and then when you get on the receiving end, you don't like it. And so it goes back and forth. They'll work through their issues. America's too strong not to have that happen.
Just ask one follow-up because it's legal related. First, you mentioned my angst. I should say I don't ask the question from angst because I'm fair and balanced on our television show. So I just raised the issue. I wasn't trying to argue on behalf of the Republicans or the Democrats. But the legal issue that you raised about the solicitor, the materials produced by Miguel Estrada when he was in the Solicitor General's office, my understanding is that every former living Solicitor General supported his position not to make those materials available. And I wondered, as a legal issue, do you or the ABA have a position on that, that is, how appropriate it was for him not to produce those materials, which apparently every former living Solicitor General supported?
It is not uncommon for great men and women who have been in a position as being privileged to be Solicitor General, having been nominated by the President of the United States and okayed by the Attorney General, to philosophically agree on issues. But I will also suggest to you that the privilege of being a United States Senator and the rules and the procedures under which they operate gives them the ability, with all due respect, to disagree with the solicitors and the like. There is no law on the books, to my knowledge, at least none has been cited, that requires the United States Senate, whoever happens to be in the majority or minority, to roll over because a number of present and former Solicitor Generals line up in support of something. That's just an issue that needs to be resolved in the United States Senate. And when the American people, at the end of the day, decide that time has come, they'll let you know with their vote as to what they approve or disapprove. Yes, sir.
Mr. Archer, just a few miles from here, Cook County Jail serves about 33,000 meals a day to over 11,000 prisoners, and most of them are there for nonviolent felonies, drug-related. And of course, you know about the issue with crack as opposed to other forms of cocaine. So I'm wondering if your organization, which I'm proud that you head, especially since you're from Michigan, but on a serious note, is there any position, any of your task forces working to sort of balance the way that is adjudicated in the courts? In other words, what can you do, if anything, to help with that disparity?
I have appointed a Justice Kennedy Commission that will look at the issue of mandatory sentences as to whether or not we should continue with them and put it back in the hands of the judiciary. The other thing that I believe that the commission will be looking at is also the sentencing guidelines, not to disturb the sentencing guidelines, as Justice Kennedy suggested that we not do, because the sentencing guidelines are needed. But we ought to look at, which is what, and we will look at his request, whether or not the sentencing guidelines would set minimums and maximums, whether or not the minimums ought to be lowered to give more discretion to our judges and justices, or judges in state and federal courts, that would have perhaps an ultimate impact on who is incarcerated. On the issue of crack versus powder cocaine, that has been a long time sore spot for many people. I mean, the reality of it is you can go to jail for a longer period of time with crack cocaine, which is cheaper than the hip so-called recreational drug of choice, cocaine. And it affects poor people disproportionately more. And at the end of the day, you wind up with what we see in our nation's prisons, where we have 2.1 million people in prison, which comprises 25% of the world's imprisoned population. And out of that 2.1 million people housed in our state and federal prisons, 63 to 65% are people of color, 40% African American, and 22 to 23% Hispanics. And when you consider that our combined population, according to the Census Bureau, is somewhere close to 26%, there is some disparity somewhere, and that also is something what Justice Kennedy asked us to look at, as well as to look at the issue of pardons and clemency that governors and the United States President has. Last question.
President
I'll
Archer.
take that back. I saw you two are the last. Go.
Okay.
Yes.
I address you not necessarily as the president of the ABA, and I'm an attorney with small practice. Probably the ABA does reflect, as does the Illinois State Bar, my practice, but also as a person who fought in that war on poverty that you referenced. And a number of your other comments suggest to many of us that you are greatly sensitive to those issues, and your distinguished career would have to bless you, if the word is appropriate, with a deep knowledge of those things that concern us. So I ask you this, not in the context of the ABA, but if there is on the minds of many of us that there really is a doctrine being pursued in Washington to carry out an established doctrine called Starve the Beast, in which the government's revenues are decreased by any manner, such as big tax cuts. And while the war might not have been planned with this in mind, I'm not suggesting it was, but the heavy cost of the war certainly facilitates that. And that is to simply render the federal government unable to fund the entitlements and take its role as it did during the war on poverty, and that this is really the most direct path to eliminate those issues. The City Club is proud and privileged to have you here as president of the ABA, but given your distinguished career, some of us, and this surely comes as no surprise to you, also think of you as a potential candidate for president of the United States in 2008. And so I ask you if you can share with us some of your feelings about what is happening in our society and the threat that may be posed by the Starve the Beast, and how you feel about that. Thank you.
Well, let me just answer that perhaps as former mayor of the city of Detroit, and simply say that there is a balance. I do not believe for 1 minute that President Bush or anyone in his administration has anything ill will towards this country. I don't believe, and would not like to believe, and would argue profusely against it, that this is being set up as some manner of ability to decline to help the poor and defenseless, to decline having a reason not to provide for the needs of our senior citizens who have been affected by the economy. The fact that the president proposes tax cuts should not be surprising to anybody. He indicated what he was going to do if he was privileged to be elected as president of the United States. When anybody runs for office and they tell you what they're going to do, it should not be a surprise. It is entirely consistent with President Reagan and President Bush 1. That philosophy we have seen. But as a mayor of the city of Detroit, I've also had the benefit of having 7 of the 8 years that I was mayor working with the Clinton-Gore administration, which had a domestic policy that provided a hand up as opposed to a hand out. And the interesting thing that I saw, for example, on the reelect of President Clinton and Vice President Gore was the number of Republican mayors who supported President Clinton and Vice President Gore or sat on their hands because they appreciated the respect that was shown to American cities, gave us the tools to lift our respective cities up and out of poverty. I mean, the empowerment zone was a godsend to the city of Detroit. I mean, our financial institutions pledged $1.1 billion to be loaned over a period of 10 years. The automotive big three said that they would pledge $600 million to be spent over 10 years. Our package to earn the right to be designated a empowerment zone city, we had $1.975 billion committed. It was irrevocable. That was the requirement. But the automotives and the businesses spent over $6 billion in 4 years. The banks loaned out all of their $1.1 billion in less than 4 years, and they're still investing in the city. When I left as mayor, we had $20.2 billion either completed of work in progress, or announced projects. That's not by me. This is by a vice president of a bank in the city of Detroit who kept tabs on all the investments. What's the point of it? The point of it is that the American public has every right, as they will in 2004, to elect a leader that they so choose. And when the candidates tell them exactly what they're going to do, it should not be a surprise. But when it occurs, it is important, now putting my hat on as the American Bar Association, that our American Bar Association and our state and local bar associations did what needed to be done back when President Reagan became president, and when President Reagan, having been beaten as a governor in the state of California by legal service lawyers who were doing work on migratory workers whose rights were being abused, he zeroed budget legal services, which was his right as president of the United States. But William Reed Smith, the president of the American Bar Association, pulled together the state and local bar presidents and other leaders to go to every one of their respective constituencies to say, no, this cannot happen, and we stopped it. So what's the message? The message is that the American Bar Association are people who care deeply about our country. At the end of the day, still have every right to let our president, to let our United States congressmen, our United States senators know what is important to America. And I don't think we're going to have any star, whatever it is, because at the end of the day, the American people are going to stand up, and people will force a change if they don't encourage a change. And thank God for Ann Williams and the other judges who impartially hear cases when we bring lawsuits to stop something that ought to be stopped. Yes.
Well, in light of the previous question, let me address you as Mr. President and ask you this. My name is Juan Thomas. I'm a young lawyer here in Chicago, and I want to thank you publicly for your appointment to the Standing Committee of Small Firms and Solo Practitioners this year. My question is, and this is just for the folks in the room, could you kind of go over your initiatives for the year as ABA president? I've heard you speak on that before. I think it would be helpful for all of us to hear what some of your key initiatives are for your term.
My bully pulpit issues: diversity, the death penalty, loan forgiveness for law students who graduate from law school and go into legal services or go into the military, and judicial independence and increase of salaries for state and local judges. I've got one other that I added, and that was the going to, for example, the National Governors Association executive director and ask him, because of my deep respect that I have for the military, would he ask all of their governors to go to their state colleges state-supported colleges and universities and ask them if they have a residency rule to waive it, so that if I'm a military personnel and I'm getting ready to send my son or daughter to a college, and I've met the residency requirements in Mississippi, and now I'm transferred to Arizona, then it hurts me because I don't make that much as a military lawyer. If my son or daughter's got to wait out, or my wife, or if I want to improve my own personal movement, then I want to be able to have that opportunity, and I lose it if I go where I'm transferred. So I either have a low morale in my family and say, we can't afford it, you got to wait for a year, because if I send you now, we got to pay out-of-state tuition, and we just frankly can't afford it. So it has low morale in the family. Or we wind up losing somebody who is who's already volunteered for service and who wants to serve their country. So I've asked the governors to take a look at that. I've asked the Conference of Chief Justices, these are the states of our highest courts. Illinois, you've already done it. Where a military lawyer who has passed the bar in Michigan comes and serves on a base here in Illinois, as long as I comply with your mandatory continuing legal education issues, I can go into court and represent military personnel on custody issues, landlord, tenant, etc. And then the last is, as I mentioned before, loan forgiveness for military personnel who leave law school owing a debt, serve in the JAG Corps. These JAG Corps officers only make $35,000 a year, and they have to pay back their debt. We need to have a loan forgiveness program to help them along the way. And then the 3 action items, I've got a summit on lawyers of color, where we are bringing in CEOs, general counsels, managing partners of law firms, etc. That will be in October at the Willard Hotel. It's being headed up by the ABA's Council on Racial and Ethnic Justice. Rachel Patrick is the lead staff person, who I think had to go back. She was here. But it's chaired by Charles Morgan, who's the senior vice president, general counsel of Bell South. And I've got a I've got a summit on women that's coming up in May at the Plaza Hotel in New York City. And the reason for that is that we've broken the glass ceiling. But if women lawyers in our profession reach up on that ceiling, there's so much jagged glass up there that they cut their hands. I'm going to pull out all that glass and give them every opportunity to be recognized for progression and succession. That's the reason why, Dean, I was looking for the opportunity to have my friend to get on the tenure track position. But in any event, the point is that I want to be able to showcase what we have to offer in our profession. And the final is to celebrate the 50th anniversary of Brown versus the Board of Education, which will be on May 17th, 2004. Brown versus the Board of Education gives all of us a chance to reflect on that important decision and what it's meant for all Americans, irrespective of color. Sees no one else standing. Thank you for the privilege of being here.